So Public Protector Advocate Busisiwe Mkhwebane will be allowed to cross-examine witnesses who testify at her imminent inquiry. The Section 194 committee is pushing ahead with that inquiry into Busisiwe Mkhwebane's fitness to hold office. The terms of reference state that the committee will provide Mkhwebane with copies of all statements as received, as well as all lists of the witnesses who they intend on calling. Let's unpack this for you now. Bring in Helen Acton, who's a researcher with Good Governance Africa. And Helen, it's lovely to see you. Thank you so much indeed for making time. We also know that this inquiry is not necessarily a judicial tribunal. It's not necessarily a court of law either. What does that tell us about, I guess, the kind of approach anyone can have towards the witnesses?
So this is great news from a good governance perspective, because it shows that Parliament is really trying to implement all the procedural fairness mechanisms that would take place in a trial, even though it is not a trial. But the rules of the National Assembly for this impeachment inquiry do say that they're going to conduct the inquiry in a way that is reasonable and procedurally fair. And so the ability to cross-examine witnesses and to call one's own witnesses is vital to this commitment to being procedurally fair, because the two main elements of procedural fairness are the phrase audi alteram partem, you must be able to hear the other side, and that the process must be unbiased. And so it's important that there is equality of arms between the public protector on the one side and the committee on the other, in that they are both able to call witnesses and to cross-examine witnesses as a means of ensuring that her hearing is fair to her. So it's very important that she is able to cross-examine witnesses. Although, because it's not an actual trial, not all the usual rules are in place, but this doesn't mean that she can abuse the process of cross-examination. The same rules should apply. She can't ask questions that are irrelevant. She can't sort of intimidate witnesses that she's cross-examining. So she must be called out on that as well. We must make sure that she doesn't abuse the process. Yeah,
the difficulty, of course, is that the public protector herself still believes that this entire process is unfair. In fact, she believes she's been treated unfairly, and it's that basis upon which she's approached the Constitutional Court. I think it's, 3 times already?
Yes. So the risk here is it is good that the Section 194 committee is making sure that there shouldn't be any element of the process that she could possibly review on the basis of being procedurally unfair. So I think that's why it's so important that they are allowing her to cross-examine witnesses. They're allowing her to be heard even after they have done this whole process, and before the final impeachment vote, she then again has the opportunity to make representations. So she's being heard, she's being included in the process, and I think this is very important so that there's no other ground for her to review this on as per her Stalingrad strategy. We want to make sure that she really has no reason to review this process as being unfair in any way. So it's important that from the beginning it is seen to be an impartial process that is really takes on all the fairness elements as if it is a trial.
Yeah. According to the Constitution, we know that heads of Chapter 9 institutions like that of the Public Protector have a 7-year non-renewable term. It's hard to believe how much time has lapsed, but Busisiwe Mkhwebane, I think, took up office, it was in October 2016. If my maths is half decent, her term actually ends next year. In that context, I mean, how much time does the inquiry really have to get to the bottom of whatever findings they find if she's going to leave office so soon?
Exactly, and that's why they've been desperately trying to forge ahead with their programs, so that they can try and possibly impeach her before her term is up. But we can see her strategy is to continually delay with litigation attempts, appeals, etc., so that she ends up finishing her term before she can be held accountable. And so that's why it's so important for our constitutional democracy to show that even those people who are in roles of holding the executive accountable need to themselves be held accountable. And we can't let her get away by delaying this process up until the end of her term so that she is never held accountable for her incompetence and her misconduct. So on the one hand, it's very important to protect these sort of institutions from any sort of arbitrary removal. So it needs to be a rigorous process, and it has shown to be one through the 17-step rules that they've adopted. that's very important for protecting the integrity of the institution. But it can't be made impossible to remove someone who's incompetent from this position. So the whole process, I think, is supposed to finish in September, and it really is important that this stays on track and that she doesn't try to delay it further. Otherwise, we could miss out on the opportunity to hold her accountable before her term of office ends.
Yeah, and let's say they don't manage to wrap things up by then. I mean, does that necessarily mean that Busisiwe Mkhwebane gets away with whatever misdemeanor she is found to have committed by this inquiry?
I would think so, because this is the way to hold her accountable. The way to remove her, the way that Parliament can hold her accountable is by removing her on the basis of misconduct and competence. And so by her term ending, I honestly don't know what could happen next to properly hold her accountable for what she's done, because what she's guilty of is incompetence, perhaps her bias and misconduct. I don't know if she could be held accountable for that in any meaningful way after her term has ended. So I think it's very, very important that they push through with the process to make sure to hold her accountable now, because Parliament is the body tasked with holding her accountable, and they're doing that work now, and there's very little they can do afterwards if she's no longer in office.
Part of the reason why this took so long to at least to even get to this point is because it's the first of its kind. This process, I think, has never been done before. We've never really thought about how you can remove heads of Chapter 9 institutions on the basis that, quite frankly, they're not fit for their jobs. Do you envision the process being much smoother in the future, given all the groundwork that's been laid to get us to this point?
Yes, exactly. So obviously when this started, there weren't any rules in Parliament to govern this process. Now there are rules. They've been obviously taken to court, and the Constitutional Court has validated the majority of the rules, with some differences to do with legal representation. And so now, as you said, the framework is there. The process should be smoother. Obviously, we hope to not have to impeach many heads of Chapter 9 institutions based on these grounds, but it's very important that we can. As much as these institutions need to be independent and protected from any form of arbitrary removal, as I said, it's very important that this process is in place. And because all the groundwork is there, it should be a quicker process. It also depends, obviously, on whether Stalingrad tactics are again employed to try to challenge every single step of the process, as has been the case here with Mkhwebane. She has almost every single step of this impeachment process, she has challenged in court. And I don't put it past her to also challenge every single step of the Parliament's impeachment inquiry now that this process has probably begun.
Yeah.
So it also all depends on the tactics of whoever's in power and who is desperately trying to hold on to their seat.
Yeah, and that, I guess, gets us back to the discussion around how much time this inquiry actually has in a context where her term is over in less than 2 years. Well, Helen, thanks very much indeed for helping us connect all the different dots. Really do appreciate your time on the AIB report this morning. Helen Acton is a researcher with Good Governance Africa.